Summer can be a bit of a slog. For us, it's often for some reason a rather busy time, and I'm sure we're not alone.
Well, you can beat the summertime sadness and the August angst and enhance your everyday with our excellent sponsor, Via Hemp. This is a company that crafts award-winning premium THC and THC-free gummies.
Each of these gummies is especially designed to cultivate a specific mood. Whether you're looking to get relaxed, get quality sleep, get creative, or just to get focused. If you're 21 or older, you can experience it for yourself and get 15% off your first order with our exclusive code MSheet at viahemp.com. That's VIIAHEMP.com.
I personally enjoyed their grapefruit flow state gummies. This CBG and CBD powerhouse really helped me tap into my productivity. Like, we have had an extremely busy summer, and I feel flow state got me over the finish line a few times when I was editing multiple episodes a day, digging through documents, and knocking out a bunch of interviews.
Via Hemp does not require a medical card, and it ships legally to all 50 states. It's also affordable, and even more so for Murder Sheet listeners who get a special deal.
If you're 21 and older, head to viahemp.com and use code MSheet to receive 15% off. That's VIIAHEMP.com and use code MSheet at checkout. After you purchase, they ask you where you heard about them. Please support our show and tell them we sent you. Enhance your everyday with Via.
Temp check. What kind of summer are we having this year? A family road trip summer? A beach bum summer? Or a wake me up when the sun sets summer? With Instacart, choose your own adventure and skip the shopping side quests. Where available, you can get ice cream delivered to your hotel, sunscreen to the pool, or cold brew to your bed. Well, door, in as fast as 30 minutes. Wherever you find yourself this summer, you can get the goods. Download Instacart for free delivery on your first 3 orders. Offer valid for a limited time. Minimum $10 per order. Excludes restaurants. Additional terms and fees apply.
Getting the smile and confidence you've been dreaming about, all from the comfort of your home, isn't a total mystery with Byte clear aligners. Just don't be surprised if all your friends start asking, "What's your secret?" Begin by ordering your at-home impression kit today for only $14.95. Byte clear aligners are doctor-directed and delivered to your door. Treatment costs thousands less than braces, plus they offer flexible financing, accept eligible insurance, and you can pay with your HSA FSA. Get 80% off your impression kit when you use code WONDERY at Byte.com. That's BYTE.com. Start your confidence journey today with Byte.
Content warning, this episode contains discussion of the murder of 2 girls. So on January 22nd, 2024, there was yet another update in the Delphi murders case, which is, of course, the case against Richard M. Allen, who is accused of murdering Delphi teenagers Abigail Williams and Liberty German back in 2017.
And, of course, what happened on the 22nd is that Judge Gull, who'd had several outstanding motions and orders on her desk, shortly after the return of attorneys Baldwin and Rosie, made a lot of decisions. So we are going to talk about those decisions and try to figure out what it might mean for the future of the case.
My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
And this is The Murder Sheet.
We're a true crime podcast focused on original reporting, interviews, and deep dives into murder cases. We're The Murder Sheet.
And this is the Delphi murders. Judge Frances Gull rules on the Franks motion. Okay, so this is a pretty short filing from the judge in this case. It's only really 1.5 pages. But
And
it got a big impact.
it packs in a lot of stuff because in our title we say she rules on the Franks motion, but she also ruled on some other stuff too, including the motion in limine. The motion in limine was when the defense team of Baldwin and Rosie filed a motion saying basically the ballistics evidence is so unreliable it shouldn't be put in front of the jury.
Right. And that is something that has worked in some states, that some judges are moving back from ballistics and tool mark identification evidence. So that's not unheard of in that larger context. In Indiana, that's not really been the case so far, at least. So I think a lot of people who are observing this saw, again, many opportunities to try to take a hit at that ballistics evidence.
The motions that the defense filed were really could be seen as a multi-pronged attack to try to get the ballistics evidence taken out of the case. And we can see, because they're focusing so much time on it, that makes sense, because it shows us that it is important to them. And it is truly important to the case, because the ballistics evidence, this is the bullet recovered at the crime scene, which the prosecution says they can prove came from a gun owned by Richard Allen.
Yeah, so it puts him at the crime scene, like, in a way that him saying, hey, I was at the trails that day, doesn't really, because a person, as we know, can be at the trails and not be guilty of the homicide, because there were other people at the trails that day. So he did the prosecution a huge favor by saying that, but it doesn't really connect him to the murders in the way the bullet, or rather cartridge, does. Now, that being said, I think there's been some very reasonable concerns raised about ballistics over the years. So I believe that the defense will have a great opportunity to really hammer away at some of that during trial. But one thing we've always said is that regardless of what happened with the filing of the motion in limine, they're still going to have that opportunity. They can bring in experts. They can attack it from just the fundamentals of, like, this is not as reliable as they're saying. And a lot of people are moving away from ballistics now. So they can still do whatever they want at trial.
Yes. But what this was about was trying to get a big win before the trial. There was trying to say the officers lied, or there's problems with the search warrant, or there's problems with the underlying evidence. And all of this was about trying to get the ballistics evidence thrown out. Because when we talk about problems with the search warrant, if you think there's a problem with the search warrant, that would be about getting rid of the ballistics evidence.
Also the confession, because if the search warrant leads to his arrest, he's put in prison, and you argue that he only confessed because he was in prison, either because he had a mental health breakdown or because Odinist guards forced him to by threatening, and he's, never said that, but maybe it happened. If you're trying to do all that, then, and he's only in prison because of the search warrant and because of what they found there, then you could argue that the confessions go too, in my opinion. And if the confessions go, that's another huge blow for the prosecution. So it's not surprising to me that they're doing all this, because if you are a defense attorney and you can get massive amounts of evidence thrown out and the case against your client is dismissed, you've done a good job. So you got to try that.
But it didn't turn out the way the defense hoped. Judge Gull basically denied everything. She said, we don't even need to have a hearing on these issues. Motion in limine is denied. Motion to suppress. No hearing on Franks.
But the Franks hearing, it's interesting. I think there was some, the thing that got all the attention was the Franks memorandum. That was like the big, media attack, because it had the theory of the case. It had all the really gruesome details about the murder of these two girls. And it had like the controversy, right? So everyone's abuzz about that. But one thing that kind of got overlooked was like the law around Franks. And Brad Rosie, one of the two defense attorneys, put something together that was a filing about, why he felt Franks was relevant there. And it did get into things around, certainly less interesting and salacious than memorandum, but certainly quite relevant. Like, what is the burden of proof around Franks? What level do they have to get to in terms of proving their case in order to even have a hearing? So it's important to keep in mind that there's when you're bringing in hearings like that, there may be some standards that have to be met when a judge is, having the discretion to determine whether or not a hearing is necessary. If that makes sense.
That makes sense. And certainly in some quarters, the fact that Judge Gold not only denied these motions, but she denied them without hearing, it's being suggested that that is a sign of bias.
Yes. But that will be the case anytime she rules against the defense going forward. That's the unfortunate situation that we're in. By keeping both parties, by keeping the judge and by keeping the old defense team, the Indiana Supreme Court has created a bit of a situation where they can basically argue at any time, I believe, that she's biased. And the obvious question would be, well, would another judge have done much different? I've not seen any indication that would be true for this latest. I mean, like, nobody's really...
It's extraordinarily difficult in the state of Indiana to get the fruit of a search warrant thrown out. There is a presumption that a search warrant is valid. With that said, there was a case last year where Andy Baldwin and his colleague David Hennessy were able to get a search warrant thrown out in the Caden Smith case, but pretty quickly afterwards, a court of appeals looked at that and reinstated the search warrant.
Yeah, so you could win at a trial level and the prosecution could appeal it, and nope.
It's very, very, very difficult to get a search warrant tossed out.
Yeah, so to me, it would have been really extraordinary had she granted any of this. So I don't really understand the argument that it somehow shows bias. I think
I don't understand the argument that it shows bias. I do understand the argument that some people could suggest. If people are already arguing that she's biased against them, any appearance can be made to further that argument.
Right. Again, that's where I look at when I'm seeing something is, would another judge likely have done different? And of course, all judges are different. Judges might come from a prosecutorial background, a defense background. That's going to influence the way they see the law and interpret it and practice. But I generally, I would want to see something where I'm like, wow, that really should have gone Baldwin and Rosie's way. That was a pretty clear win for them, and somehow it didn't go through. And I felt like the Franks motion and the motion in limine for the suppression of ballistics evidence, those seemed like long shots. Maybe long shots worth taking when you're the defense and you're trying again to get this dismissed, because if you can just avoid the trial, then that's certainly less traumatic for your client. It kind of gets him out of this. But I just, it was one of those things. But I think, there's... And
it's also important to note that just because a lawyer files a motion for a hearing on a particular issue doesn't mean that the judge is obligated to actually hold a hearing. And if a judge looks at the motion and determines, in my view, this doesn't deserve a hearing, this person hasn't made a good enough argument, I'm not going to hold a hearing, that isn't necessarily a sign of bias.
When we looked at the Franks memorandum in detail, to me, many of the more interesting and perhaps relevant and concerning aspects of it had to do with law enforcement and the handling of information, like, was this done correctly? Did they hide evidence? And we can't really know because we don't have the case file in front of us and we don't have that level of access or ability to accurately assess what law enforcement did or did not do. But when we looked at elements that we could assess, less important elements in my opinion, but still ones that we could freely look at what's what, with a researcher named Thomas, and he basically took us through the social media elements of this, where they were looking at people they claimed were Odinists and describing their social media posts. And when we looked at that, there was a lot of inaccuracies or maybe overstatement. And that made me concerned for other elements of the memorandum, because it was like, if they're really stretching and saying Elvis Fields has a picture of a arrowhead and so does Brett Holder, they must be buddies, it made me a bit concerned about other elements of it, because it's like, well, if that's a stretch, then what else is? And maybe nothing else is a stretch, but it seems like Judge Gull seems to think that there wasn't enough there either way.
This episode is sponsored by AutoTrader. Credit scores, down payments, interest rates. Car buying can be a numbers game, but you don't have to be a math expert to get the keys to your dream car. Just use Kelley Blue Book My Wallet on AutoTrader. Crunch your numbers and get your personalized results so you know exactly how much you'll pay each month for your car. It's like having a magic wand for your wallet. Presto! The car you've been wanting is now within reach. So hit the road and leave your calculator at home. Find your next car on autotrader.com.
What makes a life a good one? Is it the adventure you have? Or the friends you find along the way? Maybe it's pursuing your passion while striving to protect, defend, and save what you believe in every single day. So what makes a life a good one? In the Coast Guard, we think it's all of the above and more. But you'll have to find out for yourself. Visit gocoastguard.com to learn more.
There's nothing worse than getting home from your trip only to find you missed a can't-miss travel experience. That's why you need Viator. Book guided tours, activities, excursions, and more in one place to make your trip truly unregrettable. Viator makes it easy to explore over 300,000 travel experiences, everything from simple tours to extreme adventures, and all the niche, interesting stuff in between, so you can plan something that everyone you're traveling with will enjoy. Real traveler reviews give the inside scoop from people who've already been on the experience you're considering, so you can plan with confidence. Free cancellation helps you plan for the unexpected. And 24/7 customer service means you always have support around the clock. Download the Viator app now to use code Viator10 for 10% off your first booking in the app. Regret less. Do more with Viator.
One of the arguments, as I understood it in the Franks memorandum, was that law enforcement somehow failed in their duties because when they sought a search warrant against Richard Allen, they should have disclosed details of the Odinism theory and the Odinism investigation.
Oh, yeah.
And that would be like saying that if I wanted to get a search warrant for Kagan Klein's house, I need to also disclose prior investigations into, say, Ronald Logan. And Judge Gold didn't seem to find those sorts of arguments compelling.
One thing we've always heard from people is that a PCA does not have to include every last detail about a case. And so I'm a bit confused about that argument too. The one thing that you hear about PCAs is like, you don't have, it has to be accurate information, but do you need to include everything? No. And did they include anything about Kagan Klein? No. Did they include anything about Ron Logan? No. Did they include anything about, I'm sure, a list of other suspects that cropped up over the years? No. They don't need to. That doesn't make any sense that they would need to do that. That's not how a PCA works.
You said once that we shouldn't let conspiracy theorists or whoever,
the dumbest people on the internet, I think was my phrasing.
I would suggest this may affect good-hearted people, independent observers, people who don't have conspiracy theories. I think they could look at this and hear some of the commentary around it by some people and look at what's happened in the history of the case, the fact that Judge Gold tried to throw these people off the case. They came back. She obviously has a low opinion of them. This is chaos. This creates an impression in the minds of some people of bias.
Oh, yeah, understandably.
It's
if I tried to fire you from the Murder Sheet podcast, Kevin, and then you somehow fight it in court and come back and we have to record together, is anyone going to be comfortable listening to that show? Or are you going to be like, oh my God, that's so awkward?
Anytime Anya disagrees with Kevin, There's something else there.
Yeah, that's
so
awkward.
you don't have to be a conspiracy theorist in my mind to look at this and wonder.
The problem with conspiracy theorists in this case is not necessarily always the opinions they hold. It's the lack of nuance and open-mindedness with which they regard just general events of the case, right? I think there's a huge difference between saying, there's a conspiracy, and it's all rigged, versus saying, hey, I don't like the optics of this. Don't know quite what's going on because I can't be in anybody's heads, but this seems problematic that the Indiana Supreme Court thought that this would be the best option for what would happen going forward. Remember, I on the show said that I thought that the defense attorneys were coming back. I really did not imagine that would also include keeping the judge on.
But certainly fair-minded people can look at this and say, I wonder if there is bias. Because she's denying everything they're asking for. She's denying it so quickly. I think it's likely other judges would have made the same ruling, but who knows? I'm concerned that this sort of thing could erode faith and trust in the judicial system.
I think that's reasonable.
And I'm concerned about the long-term health of this case. I'm not sure Judge Gull is going to be able to preside over this case without being constantly being accused or suspected of bias against the defense. That's my concern.
Yeah, and it's complicated because, you kind of look at some of the stuff and people are saying, oh, this must be bias, and it's like, is she supposed to just like rule in their favor constantly to avoid the appearance of bias? Is that any better? No, but maybe that's an argument for there being a different judge on the case, frankly, because then there's not that stigma of that kind of cloud hanging over it. And let me just say, like, with this, I mean, it just makes me also wonder, is this the end of the conflict? Because, or are both sides going to take another crack at each other? They still have options to go against each other. I believe that, Rosie and Baldwin can press for a recusal, saying that she tried to kick us off. She didn't do it correctly, and it showed bias against us, and that's just going to continue going forward. So she needs to be removed. And I think she can, if, and this is a big if the Indiana Supreme Court didn't hold with the argument that they can't be removed, but more the argument that she removed them in a bad way, didn't create a good record, and didn't go about this properly, then maybe she tries to remove them again. I don't know. I mean, I guess on some level, on a human level, you'd almost like to see everyone just get along again. But I mean, come on, this is the Delphi case, so it's obviously going to turn more into, more legal drama and wrangling. That would be my bet, because that's just what we've seen so far.
And at least so far, prosecutor Nick McClelland has been silent during all of this. We all know there was a famous phone call in early October where Judge Gull asked, what do you think should happen? And he indicated at that time he believed Baldwin and Rosevich should be removed from the case. Does he still believe that? Does he still believe they deserve in some way to be sanctioned for what happened? Is he going to try to do anything about it? Who knows?
If you're McClelland and, you've seen your own office and law enforcement keep the documents and discovery materials of the case under wraps for 5 years, and then two guys come in and, like, within a year leak photos of crime scene involving 2 dead children, that's certainly that's going to be awkward going forward. I mean, and I know Mark Lehman even said, well, there's been other leaks. I feel like that's an interesting defense talking point, because it's never actually brought up what they're talking about with that. And I truly don't know. So I'd be very curious to learn, what do they feel like the prosecution did that was on the same level as what their side did?
And also, frankly, all of us have been teenagers, and I think we've all tried variations of that argument with our parents. Oh, you're punishing me for this? Well, Jimmy down the street did something worse, and his parents are okay with it. He's not getting in trouble. Did that argument work for you when you tried that with your parents? It did not work for me with
To give
mine.
them the benefit of the doubt, that argument might work on me if I knew what they were talking about and it was an applicable comparison. We've talked about, in our episode on the leak recently, we talked about a couple of other past incidents that people have conflated with this, and also how they're different and why they're not really the same thing. So I don't know if they're referring to one of those or if they're referring to something that we're not even aware of. Or if they're maybe, I don't know, maybe it's nothing. I would be very curious because that's something that, again, I've heard again and again. And I'm just always like, what are people talking about?
I'm not sure what they're referring to either. I would say if there is a leak out there that none of us are aware of, it probably wasn't much of a leak.
Yeah, that's a good point. But, I try to keep an open mind with this. And so if there's something there that is kind of on the same level, then, maybe that's a decent point. I don't know. But yeah, so it's gonna be really interesting to see how both sides navigate this going forward, because again, you have a situation where, understandably, the defense and the judge don't have much reason to really trust or like each other, and that is, you don't want a situation where it undermines the trial, in my opinion. You don't want a situation where this all just leads to an automatic appeal and there was no hope of the original trial being the end all,
That's frankly my concern, because I don't feel that the judge's decision on these motions is really that much of a shock, but it is being portrayed as a sign of bias. And as I say, I understand why fair-minded people might worry about that or be concerned that it's a sign of bias. And that makes me concerned that throughout the trial, there are going to be decisions the judge is going to make, and any one of them that goes against the defense, an argument could be made, oh, maybe this is bias. So why even throw that in? Why even muddy the waters with this? It's not even necessarily saying Judge Gull has done anything wrong and deserves to be punished. It's saying we want to have as fair a trial as possible. We want to have a trial that only happens once. We don't want to have an appeal. Why add this X factor in there when ammunition would be given to make people have doubts or concerns or lose faith in the integrity of the process?
And that's one thing I would be very interested in maybe picking some lawyers' brains about in the coming days. How concerning is this as far as an appeal goes? As long as she explains her reasoning and kind of keeps a good record, is it not as big of a deal because she can just point to that and say, here's why I ruled the way I ruled, and that's it? Or is it a situation where she can do that and there can still be a pretty powerful argument made by Richard Allen that because she tried to throw them off, that's the original sin and there's no getting around that? I would be super curious about what people think about this. Is it as dire as we're saying we think it is?
We know that it takes more than a judge ruling against someone to prove bias. A judge can rule against you. Anytime a judge rules against a person, oh my God, they're biased against me. That's not enough. But I'm concerned about both audiences. I'm concerned about what's going to happen with the case, and I'm also concerned about the fact this case is attracting unprecedented attention. People are learning about the process. They're learning about how law works. And a lot of people are
also creators are learning that the more histrionic you get about a case, maybe there's an audience for that.
This attention from the public, they're learning how the process works. Some of them are losing faith based on what they're seeing, and that's something that is troubling to me.
Yeah, there's been a lot of partisanship around the case, which is also troubling. I don't think it's a situation where it should be treated as a sports game, where this is my team, this is my side. I think it's better to just keep an open mind and be critical, but maybe open-minded about both sides, and not coming into it necessarily with like, oh, these defense attorneys are evil and blah, 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 or the judge is evil. You can disagree with stuff that people are doing and just still see it as people attempting to do their jobs. That's my opinion, at least.
And I always seem to come up with opinions or thoughts that just get people angry on both sides because I think her rulings are reasonable, which I'm sure would upset the defense, and I think she probably should be off the case, which I'm sure upsets the prosecution. So I'm at the spot where I'm upsetting everybody.
Nuance in the Delphi case, that's not allowed. I feel like every time we say something nuanced, like an air horn goes off and some Reddit SWAT team is going to kick into our house.
I feel that if any other trial judge made these same motions, there wouldn't be concern about bias.
No, there would be. There would be a lot of caterwauling because there always is. But would it affect people who are more fair-minded? No. There's always caterwauling. There's no stopping the caterwauling. That's just what people do because it gets them attention. It's but the question is, what would a reasonable person be worried about bias in that situation? My opinion is no. In this situation, my opinion is a reasonable person could be concerned because she did try to throw them off. So it's not unreasonable, and I think we're all sensitive to the fact that if this trial is just thrown out because it's totally messed up, then everybody, both sides, the families of the victims, have to get dragged through this whole thing again. And that's not fair to them because they've been through enough at this point. You want to have a good, clean trial where he gets a very fair trial and the jury weighs and chooses an outcome, and whether that's an acquittal or a conviction, it's just kind of there's some level of finality there. Some level. Obviously, there's always going to, if he's convicted, there's always going to be appeals attempts. But I think the question is, how good are the appeals attempts? Like, anybody can file an appeal, but what is it a realistic? Is there some kind of huge error at the heart of the case that's developing that will automatically generate a successful appeal? That's what you be concerned with. And it's not because, oh, he's guilty and he gets off. It's because he didn't get a fair trial in that case, and the whole thing was a huge waste of time, and that's unnecessary.
And then as we were preparing to record today, there was another filing in the case. This is something that was certainly not unexpected in the light of last week's Supreme Court decision. We all remember that after Baldwin and Rosie left the case, new attorneys came on, Librado and Scremin. Now that Rosie and Baldwin have been reinstated, Mr. Scremin and Librado have filed a motion to withdraw from the case.
No shock there.
No shock there. No one expected Richard Allen to go into trial with 4 defense attorneys. I think those are the high points.
We'll keep you posted on further developments in the case. Thanks so much for listening.
Thanks so much for listening to the Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for the Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.